On February 9, 2017, the Utah Court of Appeals issued its decision in the case of Pope versus Pope. Here's the link to the court's full decision, and we've also included the link in the video description section of this video report. On appeal, the father asserted that the district court's determination that the moral character and emotional stability factors weighed in favor of the mother, claiming that was contrary to the evidence. The district court made findings about the father's online activities, including this one. Quote, although there was nothing solidly linking father to defined criminal behavior, the court did find mother to be a credible witness. Thus, father's categorical denials of the alleged conduct caused the court to question his veracity and honesty. But the Court of Appeals concluded that it was apparent that father's alleged activities did little to influence the district court's ultimate determination that the moral character and emotional stability factors favored mother. Rather, the court explained that the primary factor contributing to its decision on this issue was that father had taken his 2-year-old son with him during a criminal episode in Maryland in which he attempted to extort money from another individual, and father's resulting felony conviction. Father next challenged the court's finding that the parties were equally capable of providing personal rather than surrogate care. The court was skeptical that father could maintain an underemployed schedule as a means of foregoing child care costs. The court likewise found mother's aspiration to be a stay-at-home mother to be economically unreasonable, even after her upcoming remarriage. The district court concluded that in the long term, quote, the most likely scenario is that both parties will need to be gainfully employed on a full-time basis to adequately provide for the needs of themselves and the minor children as they mature, close quote. Father also challenges the basis for the district court's related conclusion that the parties' relative financial conditions favored mother. Father argues that the district court inappropriately favored mother's step-parent household over father's multi-generational household by taking into account the income of mother's fiancé when analyzing her financial circumstances, but refusing to also consider grandmother's income in father's favor. The Court of Appeals, however, concluded that the court did not err in failing to consider grandmother's income in analyzing father's financial situation because there was no basis for the court to conclude that grandmother planned to make long-term financial contributions to the children's care as mother's fiancé planned to do. Father next challenged the district court's ruling that the children should change schools and attend school in mother's neighborhood. Father did not specifically argue at the trial that the children would be emotionally harmed by changing schools. Father never attempted to present even general evidence that the effects of changing schools are deep and permanent, let alone specific evidence that his children in this particular situation would suffer as a result of a move. Father, while a change in schools argued could be difficult for a child, did not convince the court that the transitory distress from such a move would be, as a matter of law, necessarily outweighing other factors that might impact the child's well-being. Given the significant discrepancy between the academic performance of the two schools in questions, with the school of mother's neighborhood ranked significantly higher than the school in father's neighborhood, it was within the court's discretion to determine that under the particular circumstances, the educational opportunities afforded by the school in mother's neighborhood outweighed the benefits of ethnic diversity at the school in father's neighborhood, which was what father's argument was. As well, any concerns about how the children would adjust to a change in schools was not a significant factor either. This is especially true where the father's instability of living introduced some uncertainty about whether the children would be able to continue attending their current school. Finally, father argued that the court exceeded its discretion in permitting mother's fiancé to testify despite his having remained in the courtroom after the witness exclusion rule was invoked. Although the fiancé was on the original witness list, mother's counsel did not intend to call him as a witness, which is why he was not excluded from the courtroom when the rule was invoked. Rather, mother's fiancé testified at the district court's own request. To show that a trial court abused its discretion in allowing a witness to testify despite a violation of the exclusionary rule, the objecting party carries the onus of showing prejudice, and in particular must demonstrate that the witness changed his or her testimony in some material way because of what he or she heard. In addition, rulings on the evidence are looked upon with a greater degree of indulgence when the trial is to the court than when it is to a jury, because it can be safely assumed that the trial court will be somewhat more discriminating in appraising both the competency and the rulings properly to be given evidence. Given the deference the appeals court grants the trial courts and the fact that father failed to present evidence suggesting that mother's fiancé altered his testimony based upon what he heard in the trial, the Court of Appeals was not persuaded that the fiancé's testimony resulted in unfair prejudice or that the court exceeded its discretion in permitting the testimony.